Good afternoon from Hong Kong. This is Joe Liu, Deputy Secretary General of the Hong Kong International Arbitration Center. Welcome to the HKIAC's webinar series. Today's webinar is about do's and don'ts of drafting arbitration clauses and has 4 parts. First, we will hear from Juliet Blanche on key drafting points for arbitration agreements. Julia is a full-time arbitrator at the Arbitration Chambers in London. She has over 30 years of experience in the arbitration of international commercial disputes and has acted as counsel and sat as arbitrator in disputes under major arbitration rules and seated in a variety of jurisdictions. Then we will hear from Carl Hennessy on the best way to secure the best possible arbitration agreements. Carl is Senior Vice President of Litigation, Investigations, and Regulatory Affairs at Airbus, where he has the group's global activities in those areas. He occasionally sits as arbitrator and serves on the board of directors of companies and nonprofits. Until July last year, he served as chairman of the governing body of the ICC Court of International Arbitration and is now a member of the HKIAC Council. Then I will give a presentation about HKIAC's role and experience in dealing with problematic arbitration clauses and give some real-life examples for discussion. The final session is devoted to Q&A, during which the speakers will answer some of the questions posed by the audience members. During the event, the audience can pose questions to the speakers by using the Q&A button on your screen. Today, I'm pleased to announce that we will also introduce a new feature, which is polling questions. We will pose a polling question in relation to each presentation. On that note, I will put out the first polling question before Julia kick off her presentation. You should be now able to see the first polling questions on your screen, and you have 15 seconds to answer the questions, and then we will show the results. Now you should be able to see the results of the first polling question. The question is, which of the following components of an arbitration agreement is most important for you? As you can see from the results, the seat of arbitration is the most chosen result for this question. Now, I have the great pleasure to invite Juliet to give her presentation on the key drafting points on arbitration agreements. Juliet, over to you.
Thank you, Joe. And thank you to the HKIAC for asking me to speak to you all today. It's a great honor. Good afternoon to all of you in Asia. Good morning to you in Europe. And if there's anyone here else from other parts than Asia and Europe, I'm seriously impressed that you're not asleep. I hope to set the scene by explaining why arbitration agreements are necessary and what they should contain before I pass the microphone to Carl. So why do we need an arbitration agreement? Well, there's no right to require a counterparty to go to arbitration in the absence of an agreement. You have the right to go to court, but you have to have an agreement to go to arbitration. The agreement to arbitrate is most commonly found in the commercial contract between the parties, and Carl will talk shortly about the process of negotiating it. However, it is also possible for the parties to enter into a separate arbitration agreement, and that may happen. You may have a master arbitration agreement if you have a suite of documents, for example, a complex financing or construction documentation, or the parties can agree to go to arbitration once a dispute has arisen. I would say trying to agree arbitration procedure after the dispute has arisen is hard. It's difficult for the parties to come to an agreement on anything once they're in a dispute. So the ideal time to think about what you want in your arbitration agreement is the same time that you're negotiating the underlying contract, a time when the parties are still trying to work together to achieve something. It's also important to understand that an arbitration agreement is a self-standing agreement. It's divisible from the underlying contract, and it can survive the termination or invalidity of the contract. So, for example, if a party asserts that the contract is invalid, or void or terminated for some reason, the arbitration agreement will remain in existence, entitling the counterparty to commence arbitration proceedings in respect of any claim for damages or other exercise of right arising out of that contract. Joe, can we go to slide 2? So what are the key issues to decide when looking to negotiate your arbitration agreement? Well, one of the first is whether to have an institutional arbitration or ad hoc. An institutional arbitration is one where the parties agree that an institution, such as the HKIAC, will administer the arbitration. And there are many benefits of an institutional arbitration. In particular, you will incorporate into the agreement the institution's set of rules, and these rules are well thought through. They've developed as the institutions have seen the types of problems that come up. And those institutions like the HKIAC publish their rules in numerous languages, and you incorporate those rules into your arbitration agreement merely by reference to the institutional rules. Secondly, the institution will administer the arbitration process. And what this means, they'll supervise the appointment of the arbitrators, the process of the arbitration, and also administer the issuing of the award. Some institutions, such as the ICC, will scrutinize the draft award, and most institutions will, if asked by the tribunal, read the award carefully to see if there are any obvious errors that should be drawn to the attention of the tribunal. Financial. The institution will determine the tribunal's fees. And typically, they will either provide for an ad valorem fee, which depends on the amount in dispute, or an hourly rate for the tribunal. And most institutions will have a cap on the hourly rate that the tribunal can charge. The institution will also hold the deposits, determine when deposits should be paid, and will remit any balance to the parties at the end of the dispute, if there is a balance, of course, after the tribunal has been paid and the institution has paid its administrative fees. And finally, and parties often don't realize this, the institutions have excellent secretariats that the parties as well as the tribunal can contact if they have questions. And indeed, you can contact the secretariat for help even when you're negotiating your arbitration agreement. One really important point: if you're going for institutional arbitration, please make sure that the institution actually exists. I did a case many years ago where the arbitration clause specified arbitration in Stockholm before the Stockholm Arbitration Court. Now, there is no Stockholm Arbitration Court. The tribunal initially held that they had jurisdiction to hear the dispute as an ad hoc arbitration seated in Stockholm. It took 5 years for us to get to the final hearing. It was a very contentious dispute. We'd had various changes in the constitution of the tribunal during that time. And after the final evidential hearing, as I say, 5 years later, the tribunal decided that it did not have jurisdiction. We did appeal this, we were successful, but that was 5 years wasted and sadly millions of dollars wasted. Ad hoc arbitration. Well, this is one where the process is managed by the parties. So the parties will decide the procedural rules. This can make the process more flexible. However, it does depend on the parties being collaborative. And this is not always the case. It works well, for example, where the parties are in a continuing JV and are willing to work together to fight the dispute. One of the main problems with an ad hoc arbitration is that it's up to the parties to agree on the rules to apply to the arbitration. And there may be gaps in the rules that the parties have negotiated, and the parties then have to turn to the courts for help. For example, who's to appoint an arbitrator if one of the parties refuses? Is the tribunal empowered to order interim relief? For this reason, parties may incorporate the UNCITRAL rules, but note, the UNCITRAL rules, which are a set of arbitration procedural rules, but UNCITRAL is not an institution and it does not administer arbitrations. Another significant problem with ad hoc arbitration is that there's no independent third-party body reviewing the fees of the tribunal. It means the parties have to negotiate the fees direct with the tribunal. And finally, it's not uncommon in an ad hoc arbitration for the tribunal to turn to an institution to ask it to act as fund holder. And in that event, the institution will charge for the fees to be that are incurred in managing the deposits. Joe, can we go to slide 3, please? Now, this interestingly was the factor that the parties in the pre-poll all said was the most important. So why do you all think that the seat or the legal place of the arbitration is important? Well, firstly, it means that the arbitration is subject to whatever the national arbitration legislation is, excuse me, in that jurisdiction. So for example, the Arbitration Ordinance in Hong Kong, or the Singapore International Arbitration Act, or the Arbitration Law of the People's Republic of China. And these statutes will each have mandatory provisions which you cannot contract out of. Many countries' arbitration statutes are based on the UNCITRAL model law, but not all. The second importance is that it will affect the ability and likelihood of intervention by the local courts. Now, that intervention may be welcome, but it may not. So the sorts of things that you'll be looking for from the courts is the ability to get interim relief, whether you can challenge the arbitral process or whether you can challenge a member of the tribunal. Can you appeal the award, or can you get an injunction preventing the arbitration from continuing? Further importance is whether the seat is a New York Convention country. Obviously, if it's not a New York Convention country, then it will adversely affect your ability to enforce the award if you're successful. And finally, and this is only to an extent, it may impact the procedure in a more soft way. For example, if the seat is a common law country, you may find that the tribunal adopt a more common law approach, and vice versa with a civil law approach. Now, any experienced arbitrator is not going to be particularly concerned by that. They're going to look for what the parties wanted. But there are obviously differences in the civil and the common law approach, and that's something to take into account. So concluding on this, just by the use of the words Hong Kong seat, HKIAC rules, you can incorporate into your arbitration agreement the whole of the Hong Kong Arbitration Ordinance and all the HKIAC rules. So let's go on to some other laws that may be applicable. So there are potentially 3 different laws which can apply to the dispute. I'm actually going to go in a different order from those in the slide. So firstly, the substantive law of the contract. Now, that's the law which determines what the contract means and what the parties' rights and obligations are. And it doesn't have to be in the arbitration agreement, but is often found there. Secondly, there's the law of the seat, so the Curio Law. And that's the law which determines the procedural rules governing the arbitration, as we briefly talked about in the previous slide. However, there may be a third law, and that's the law that governs the arbitration agreement itself. This is because the separate nature of the arbitration agreement means you can't assume that the governing law of the underlying contract will be the same as that of the arbitration agreement. If the governing law of the arbitration agreement is not stated, and if the procedural law and the substantive law are different, there can be a dispute as to which is the applicable law governing the arbitration agreement. Well, you may ask why that matters. Well, the main reason is that it will be the law governing the arbitration agreement that will determine whether the dispute is arbitrable. And different countries have different rules as to what disputes can be taken to arbitration and which disputes must go to court. So it's really sensible to include in your arbitration agreement what law is to govern the arbitration agreement. So let's go on to the final slide and look at some of the other important factors. So the number of arbitrators. For obvious reasons, it should be an uneven number, normally 1 or 3, but I have been involved in an arbitration where we discussed having 5 arbitrators. The things to think about in terms of number of arbitrators are the complexity of the dispute, the value, the speed. Generally, if you have 1 arbitrator, it will be cheaper and quicker, but one of the key problems is that parties will not feel that they've had the opportunity to have their chosen arbitrator on the tribunal, and that can significantly lessen their confidence and belief in the process. Then looking at specific requirements for the arbitrators. I know Carl's also going to talk about this, so I won't go into depth, but You can, if you want, say what type of legal expertise you want, nationality, technical expertise, but do be careful. I had an arbitration many years ago again, where the clause required the presiding arbitrator to be a Finnish professor of law of 30 years standing, fluent in English and Russian, and with a very specific industry sector expertise. And my co-arbitrator and I spent a year trying to find somebody who met all those requirements and who was willing to be appointed as presiding arbitrator. The parties refused to allow any flexibility to us. After a year, they gave up and they settled the case. The scope of the disputes subject to the arbitration. Do you want all the issues arising out of the contract to go to arbitration? Or will some of them, for example, be subject to expert determination? Is it to cover contractual and tortious disputes? Then language of the arbitration. Are you having just a sole language or dual language? And if you're having dual language, think it through carefully, because you may find that each party adopts one of the languages. And you need to make sure in which case that you have a tribunal that's fluent in both languages. Multi-party, what are you doing if there are more than two parties to the contract? And will those parties automatically fall into two groups if there's a dispute? Or might you have some parties who won't be involved, or some parties who won't agree with others? Multi-contract, do you want to have the ability to consolidate disputes that arise under different contracts if they all come out of the same subject matter? So again, construction is a typical area where you'll have a number of different contracts with different parties, but with the same subject matter. Do you want to provide that you can consolidate them? And many institutional rules will cover this. Confidentiality. Do you want to put in an express provision for confidentiality? Now, some arbitration institutional rules cover confidentiality, but some don't. And we should all be aware that there's an increasing push to transparency. And therefore, if confidentiality is important, I strongly recommend including it. And finally, you may want to include specific rules, for example, the IBA rules on the taking of evidence, or the Prague rules, which are a more civil law approach to the taking of evidence. So that is a quick run through. And I've just seen some of the questions. There are some really interesting questions coming up already that I look forward to discussing in the Q&A. But I hope that's given a general overview of the importance of the arbitration agreement. Before we go on to Carl, we're going to run the poll again, just to see if what I've said has changed anybody's minds as to what's important and not. So Joe, over to you, and thank you to everybody for listening.
Thank you, Juliet, for the presentation. Lots of important points there. So I think the audience can now see the question again on the screen. You'll have 15 seconds to answer. Thank you for answering the question. I can see that the answer remains largely the same. The most important component of the arbitration agreement remains the seat of arbitration. Thank you, everybody. And now I will turn to Carl, who will focus on how to secure the best possible arbitration agreement. Over to Carl. Thank you.
Many thanks, Joe. Many thanks to HKIAC for inviting me to speak today, and many thanks to all of you for turning up. So good morning from Paris and good afternoon to all of you from joining us from Asia. If Joe, you could please go to the first slide. So I'm going to talk to you today from the perspective of someone who has both served as outside counsel, but has spent most of my career in-house, and also occasionally sits as arbitrator, and try to share with you the best wisdom I can about practical ways to secure an agreement that is going to work. I want to emphasize that in doing so, you shouldn't view this as a unilaterally sort of zero-sum game or something that you're trying to do as a competitive point of view. That will generally lead you down the path to a pathological clause, to a clause that is one that the other party seeks to avoid, or to a clause that may even be seen as overly constraining by a court or other judicial authority, or even by the tribunal itself. So I really want to emphasize practicality in doing so. The first piece of advice I can give is to keep it simple. Complexity in the name of dealing with contingencies that you foresee runs immediately into two problems. The first is that primarily you may not be able to foresee the contingencies that will truly matter, and you may find that at the time the clause is actually applied, you're tripping up over some of the attempts that you made to deal with the contingencies that you thought would arise. Complex clause negotiation can lead to untenable compromises. The example that I can give from an actual contract that I was faced with several years ago appointed the Paris courts, the commercial courts, as the sole authority to settle disputes, but then sought to apply the ICC rules and have the Paris judges speak English. For anyone who's ever litigated in a civil law environment, particularly in France, you'll know that that kind of compromise was a simple non-starter. And when I spoke to the individuals who were involved in the negotiation itself, they said it was an 11th hour compromise to allow the final clause of the contract to be settled. So on the one hand, giving everybody what they want is not an option, but at the same time, finding a practical compromise is an absolute necessity. I want to point out something important, which is that if you find yourself bogged down in the question of, say, the seat of an arbitration, or even the language of an arbitration, perhaps over clauses dealing with disclosure issues or others besides, you may actually have a signal that there is something else wrong with your negotiation. In other words, that the focus of the discussion shouldn't necessarily be on the DR clause, but on the underlying tension itself that may lead you to the point where that becomes a do or die for you. So rather than trying to steal or gain some advantage in the DR clause itself, why not put the issue that is the underlying tension on the table so that it can actually be discussed and resolved at the contracting stage and does not become something that leads to a dispute at a later time. If Joe, you can go to the next slide. I'd mentioned before the need to avoid the idea that the DR clause is a zero-sum competitive matter. I was fascinated in the poll in Juliet's section to see the number of participants who are wed to the idea of the location or the seat of the arbitration. That is, in my mind, something of a signal that there may be an idea that this is a competitive matter. A matter of pride, personal or national, is something that often enters into a negotiation. I would caution those of you who are looking at this as a matter for some advantage to be very cautious with that. If in any issue that is raised as a point for negotiation, and Juliet's given an excellent list in the 4th slide of her presentation, you find yourself bogged down and inflexible, take a step back and ask yourself the question, are you indeed setting up a dispute about the dispute resolution clause at a later time? One of the examples that I often see is where one party is insisting on an obscure local institution that doesn't necessarily have international experience or international respect and unwilling to consider alternatives. So whenever you find yourself discussing a dispute resolution clause, be prepared to explain in terms that offer advantages to both parties. Any point on which you are unwilling to compromise, and those points should always be related to the enforceability of the award, the neutrality of the institution, or to other matters where both parties can see the advantage. Simply insisting on an internal policy, even if it's quite important to you, is rarely going to be a recipe for success. The second point that I would encourage you to consider is that if you are successful in imposing a point of view that you consider a win for your client and a disadvantage for the clients on the other side or your party opposite, please be aware that you may simply have created the kind of problematic proceedings that Juliet referred to in one of her examples. I am quite sure that the parties at the time that they negotiated the clause referring to a narrow set of criteria for the president of the tribunal congratulated themselves on having identified the perfect individual to chair an arbitration. If they had taken a step back and considered the practical difficulty of identifying such a candidate at the time their dispute would actually arise, perhaps they would have saved themselves a lot of time. Never forget that the basic purpose of a dispute resolution clause is to resolve disputes, not to foster them. and try to avoid that you actually create an incentive upfront for the party that you have quote unquote defeated in the negotiation to begin to seek to avoid the clause that you have just decided. And I would add as well that arbitration is not the only option. If you find that you are stuck on a dispute resolution clause negotiation, there may be other options that you can consider. Dispute boards, med-arb, mediations, or conciliation processes may be available to actually help you resolve a dispute where the DR dispute clause is being viewed in narrow terms just for arbitration. Next slide, please. I know that some of you are possibly using ad hoc clauses today. That is an option that does have some attractions, as Juliet has outlined them. In my personal point of view, I choose to rely exclusively on institutional rules, the law of a neutral seat, and to take advantage of work done by experts to set parameters. What does this mean? I believe that the money that's paid to institutions to administer arbitrations and to be available as professional secretariats are to answer procedural questions as the arbitration is underway is worth every penny. My grandfather had an expression which I'm very fond of in these circumstances, which is there is nothing in this world that is as expensive as cheap. And I find that that is certainly true in arbitration, that the cost of arguing through every small point in terms of the rules, even if there are a block set of rules such as Arbitrary available, is indeed a greater cost than the institutional costs, which are quite minor by comparison. A study conducted by the ICC, and I believe that similar patterns would apply for other institutions as well, pegs that the cost of the institutional costs of an arbitration are between 5 and 7% of the total. In other words, a vanishingly small percentage of the total cost of the dispute itself to the parties. I would also encourage you, for those of you who still consider ad hoc as an option, to at least adopt the Arbitrary rules, or a set of rules that would govern the dispute itself, because entering a dispute with no rules and no institution to help you resolve the differences between the parties does indeed indicate a sense of optimism that I would find unjustified for nearly any of the hundreds of disputes that I've handled through my career. I think that it's fair to say that there is going to always be a personal preference, in many cases formed by the background as a common lawyer or as a civil lawyer, between the disclosure. Settling the approach to disclosure would indeed be something that I would encourage the parties to do upfront. That is a contentious point that arises very early in most disputes and can cost a great deal of goodwill as well as time and money. The IBA rules and the Prague rules do have key differences and do offer a good jumping off point. And when dealing with parties from North America, one can often find that there is insistence on using domestic rules, such as the Federal Rules of Civil Procedure of the United States of America. I do think this is something worth considering up front and would encourage all of you to look into those rules in advance. Next slide, please. Finally, I would also like to encourage, for those of you working even in smaller companies or smaller enterprises, and certainly for all of you working in larger enterprises or handling matters for larger clients, to encourage the adoption of a dispute resolution policy. A dispute resolution policy, it can be as simple as model clauses that would apply in different types of contracts, and it can be as comprehensive as an A to Z guide on how disputes may be handled from the contracting phase all the way to the award and enforcement phase. At Airbus, we have such a comprehensive policy, but it's not necessary to think of a policy that is that complex or that's developed. I do suggest that anyone who is advising clients take a step back and look at the place of the client in the marketplace, the bargaining power held by that client, and also the opportunities that may be available to simplify across an entire portfolio of disputes the commercial difficulties that may arise as a result of a dispute that takes place at all. This requires a close consultation with the commercial colleagues, the salespeople, procurement, and others to understand their interests and to understand their preferences in terms of dealing with disputes. It's often misunderstood that the role of a disputes lawyer is at the end of a relationship. I think instead, Juliet referred in her presentation to something I find to be generally true. Arbitration in particular is usually only applied in cases where there is an ongoing relationship and where the overall objective, if one takes a step back, is to reestablish the parameters of that relationship and therefore to do as little harm as possible to the commercial relationship. There may, of course, be exceptions, but I'm reminded of the poll taken informally by a good friend of mine, Michael McElrath, of GE Baker Hughes, when he asked a series of practitioners in the market, external counsel, how long should an arbitration take? The average answer, a year. Also fellow in-house counsel, how long should an arbitration take? The answer was 3 to 6 months. And then he asked commercial colleagues who were not lawyers, in other words, our internal clients, how long should it take? The average answer was between 3 weeks and a month. So we quickly get an idea of the perceptions of the process and the needs expressed by commercial colleagues. The truth will always be somewhere in between, but it's important when establishing a dispute resolution policy that that policy is responsive to the needs of the ultimate user and not just the lawyers themselves. Personally, if I had been answering the poll that was given during Juliet's presentation about the most essential aspect for me in terms of the bargaining that's to be struck, for me it would be the choice of institution. The choice of institution being the focus of the discussion has 3 advantages. First of all, it provides the greatest opportunity for efficiency. By choosing the HKIAC, one is assured upfront of the advantages of enforceability, also including in the People's Republic of China, which is a fairly unique advantage, the assurance of a quality secretariat, the assurance of the worldwide perception of neutrality, and other advantages besides. The second advantage is if that choice is applied consistently, one may not be able in advance to foresee all of the circumstances in which joinder of proceedings is necessary or useful, but that option remains open. And third and finally, it provides distinct advantages when there are multiple disputes across multiple contracts, even if these aren't to be joined, in terms of the efficiency of working with counsel and in terms of the understanding internally of the process by commercial stakeholders. So a simple advance analysis of the interest that your client is likely to have in a full portfolio of disputes is definitely something that should be done. A dispute resolution policy costs nothing to establish and may serve great benefit further down the road. So with that, thank you very much, and I'll transition back to you, Joe.
Thank you very much, Carl. I think you've made a lot of excellent points there for the audience to take away with and for us to apply when we are drafting and negotiating arbitration agreements. And now it's time for us to put out the second polling question. You should be able to see it on your screen. You have 15 seconds to answer. Here are the results. So the strategy the audience have used, most audience members have used when drafting arbitration agreement is using arbitration institutions model clause. That's a good news for us. Thank you. So now I would like to spend about 15 minutes to speak about HKIAC's experience in dealing with problematic arbitration clauses. We see new arbitration clauses submitted to HKIAC almost on a daily basis. Despite the fact that many arbitral institutions have published their model clauses, and we have many experts like Juliet and Carl who have strong expertise and experience in advising on arbitration clauses on the market, we still see unclear or problematic clauses and the parties spending time and costs arguing about the proper construction of those clauses from time to time. An issue that we often deal with is when a party submits a problematic clause to HKIAC, whether HKIAC should take the case and how we should proceed. HKIAC's role and the standard it applies in deciding how to proceed in this scenario may depend on the applicable arbitration rules. In this presentation, I will focus on HKIAC's role and the relevant process under HKIAC's main arbitration rules, namely the 2018 HKIAC Administered Arbitration Rules. The role of HKIAC in dealing with the jurisdictional question at an early stage of the arbitration is set out in Articles 19.4 and 5 of the 2018 rules. HKIAC plays this role at any point after the commencement of the arbitration and before the constitution of the arbitral tribunal. Our role is triggered where the question arises as to the existence, validity, or scope of the arbitration agreement. For example, a party alleges that it is not a party to the arbitration agreement, or whether a single arbitration has been properly commenced under Article 29 of the 2018 rules. For example, the respondent may allege that the claimant has commenced a single arbitration under multiple contracts that do not concern the same transaction or a series of related transactions. Or whether HKIAC has the competence to administer the arbitration. For example, the arbitration clause in question provides for an ad hoc arbitration that includes no reference to HKIAC. When any of these questions arises, HKIAC will decide whether to proceed with the arbitration. The test HKIAC will apply in that regard is a prima facie one, and it is set out in Article 19.5. If the question concerns the existence, validity, or scope of the arbitration agreement, or HKIAC's competence to administer, the test is whether an arbitration agreement under the 2018 rules may exist. To assess whether the 2018 rules apply to the arbitration agreement, HKIAC will have regard to the test in Article 1.1, which is whether the arbitration agreement provides for the rules to apply, or arbitration administered by HKIAC or words to similar effect. If the question concerns the commencement of a single arbitration under multiple contracts, the test is whether such arbitration has been properly commenced in compliance with the requirements under Article 29. I want to emphasize here that when HKIAC is faced with a jurisdictional question, we do not decide on the merits of the jurisdictional issue. Instead, we will only decide whether to proceed with the arbitration. If we decide to proceed, the question will be left to the tribunal to determine, and our decision is without prejudice to the admissibility or merits of any party's case. My final point on this slide is that there is a similar process for HKIAC to perform a similar role under the 2013 version of the HKIAC Administered Arbitration Rules and the 2015 procedure, which HKIAC apply in administering arbitrations under the UNCITRAL rules. So how does HKIAC exercise its role in practice? On this slide, I've summarized 6 key takeaway points. The first point is, before HKIAC makes a decision on whether to proceed, we will always seek and consider the comments from all parties. The second point is that the starting point is the terms of the arbitrations agreement. As each arbitration agreement may be different, HKIAC's decision in each case is based on the terms of the agreement and the specific circumstances of the case. Thirdly, when assessing whether the 2018 rules apply, HKIAC will have regard to the test in Article 1.1 and construe it broadly. The part of the test that is often a point of contention is the language arbitration administered by HKIAC or words to similar effect. In that respect, HKIAC will be looking for any identifiable reference to HKIAC and whether there is any basis to establish the party's intention for HKIAC to administer the case. Fourthly, when deciding whether to proceed with an arbitration, HKIAC will apply the test under Articles 90.4 and 5. The test here sets a very low threshold, which will be met if there is even a tenuous evidence that the parties may have an arbitration agreement under the HKIAC rules. In practice, HKIAC is slow to discontinue an arbitration in the face of a jurisdictional objection at an early stage. We will generally proceed, leaving the jurisdictional issue to be determined by the arbitral tribunal once constituted. Here I present 4 types of unclear clauses we typically see in our cases. They are unclear in different aspects. The first type of clause does not specify the name of an arbitral institution. I've given 2 examples here. The first clause provides that the arbitration is subject to consideration in an arbitration court of Hong Kong. The second is through the established arbitration institution of the People's Republic of China. As you can see, both clauses do not specify the name of an arbitral institution. In both cases, HKIAC eventually declined to administer the arbitration. The second type of a clause does not specify the role of HKIAC. Here, the first clause provides that the dispute shall be submitted to the Hong Kong International Arbitration Center. The second example provides that arbitration in Hong Kong brackets Hong Kong International Arbitration Center. Both clauses do not specify the role of HKIAC, whether HKIAC shall act as the administering institution, appointing authority, the fund holder, or provide any other administrative support. It is not clear. The third type does not specify the rules. The first example here is arbitration in accordance with HKIAC's rules. The second example provides that arbitration at the HKIAC subject to the procedures applicable there. Now, for those who may be familiar with HKIAC's procedures will know that HKIAC has published multiple sets of arbitration rules. Our main rules are the HKIAC administered arbitration rules, but we have also published our procedures for HKIAC to administer arbitrations under the Unclear rules, HKIAC domestic arbitration rules, security rules, etc., etc. So a reference to HKIAC rules and the procedures applicable therein may create arguments as to which HKIAC rules shall apply. The fourth type of unclear arbitration clauses I presented here does not specify the version, the applicable version of the rules. The first example here provides that arbitration in accordance with the HKIAC administered arbitration rules then in effect. The second clause provides in accordance with the Unclear arbitration rules as at present in force. And these clauses may lead to arguments as to whether the arbitration shall be governed by the arbitration rules in force as of the date of the arbitration agreement or at the date when the arbitration is commenced. Now I want to discuss 2 real-life problematic clauses HKIAC has dealt with. You can see the first clause on the screen, which provides that in case no settlement can be reached, the case under dispute shall be referred to and finally resolved by arbitration in Hong Kong in accordance with the arbitration rules of the Hong Kong International Arbitration Center, bracket SIAC rules, for the time being in force. The tribunal shall consist of 1 arbitrator to be appointed by the Singapore International Arbitration Center. Your first impression would be like, probably, what a combo. Now, what are the parties' arguments? The claimant commenced the arbitration after the 2013 rules came into force, and its position was that the 2013 rules should apply because the respondent had accepted that in a separate Chinese court proceeding between the same parties, that the references to the SIC rules and SIC were typos and a mistake of its employee. Secondly, it would not be workable for SIC to appoint an arbitrator in an HKIAC arbitration. Thirdly, since the parties agreed to apply the 2013 rules, HKIAC should be competent to appoint the sole arbitrator. The respondent disagreed. They submitted that the arbitration agreement indicated the parties' agreement to apply the rules of either HKIAC or SIC. The respondent also argued that HKIAC did not have the authority to appoint because the clause clearly designated SIC as the appointing authority. So what is HKIAC's approach? After considering both parties' positions, we noted that both parties accepted that the clause provided for at least the possibility of applying the 2013 HKIAC rules. Therefore, there was a prima facie basis that an arbitration agreement under the 2013 rules might exist. This view was supported by the respondent's position in the PRC court proceedings, in which it considered that the reference to SIC was a typo. On those bases, HKIAC decided to administer the case under the 2013 rules. With respect to the appointment of the sole arbitrator, HKIAC noted that the clause clearly provided that SIC shall be the appointing authority. While this was unusual, it was not incompatible with the 2013 rules, as the appointment procedure in the rules was a default procedure, and it could be varied by the parties' agreement. We then invited SIC to appoint a sole arbitrator in accordance with the 2013 rules. When we approached the SIC, we provided the information regarding our appointment procedure under the 2013 rules, as well as the documents that needed to be completed during the process. SIC eventually made appointment accordingly. I selected this clause not only because the arbitration clause referred to two institutions, but also to highlight the importance of institutional collaboration, which can sometimes resolve the deadlock created by an otherwise pathological clause. Now that I have talked about HKIAC's approach in this case, as mentioned before, our decision to proceed is without prejudice to the tribunal's decision on the jurisdictional issue. So I'm interested to hear any thoughts from Juliet as to how she will construct this arbitration clause if she were appointed as the sole arbitrator in this case. Juliet, your thoughts, please.
Many thanks, Joe. I would first say that there is clearly an intention from the parties that they want to arbitrate. I can find in the wording that the parties both agree that they want to go to arbitration. So there's an arbitration agreement. It's just a case of where and how. I would then have said there is a clear intention that the arbitration is to be seated in Hong Kong, and there seems to be no dispute about that. I would then go to look at the specific wording, actual words of the Hong Kong International Arbitration Centre, compared to just the SIAC in the parentheses. And I would take the view, as did the HKIAC, that the SIAC is a typo. The parties are both clearly thinking also of the SIAC because they're looking at the arbitrator to be appointed by them. But given the concession by the respondent in the related PRC court proceedings, I would take the view that it is a 2013 HKIAC rules. And finally, I would also have agreed with the tribunal, with the sole arbitrator being appointed by the SIAC. So to conclude, I would have taken jurisdiction on the basis it's 2013 HKIAC rules arbitration seated in Hong Kong.
Thank you, Julia. I'm very pleased to hear that. It's in line with our decision. Thank you. So now I will turn to the second clause. You will see that on the screen. It reads that any dispute arising out of the breach of this contract or any disputes that cannot be resolved by negotiation shall be submitted to arbitral institution that is situated in the place of residence of the purchaser in accordance with arbitration rules. In this case, the place of residence of the purchaser was Hong Kong. So what was each party's position? The claimant commenced the arbitration under the 2013 HKIAC administered arbitration rules, and it argued that the clause permitted HKIAC to administer the case under the 2013 rules because the language of the clause indicated that a dispute be resolved by institutional arbitration. Secondly, While the clause did not specify the name of the arbitral institution, the parties should be able to submit a dispute to any arbitral institution in Hong Kong, including HKIAC. Thirdly, the use of the words submitted to an arbitral institution were words to the effect that the arbitration was intended to be administered by the relevant institution. In this case, the respondent did not participate, so they did not provide any comments on this arbitration clause. Having given the opportunity to all parties to comment on the clause, HKIAC made the following decisions. Having considered its past practice, we consider that it would be competent for HKIAC to administer the arbitration under the 2013 rules on a prima facie basis because the wording submitted to was arguably sufficient for HKIAC to administer the arbitration under the 2013 rules. The clause indicated the party's intention to submit disputes to arbitration under the rules of a Hong Kong arbitral institution. Therefore, the claimant was entitled to commence an arbitration under the 2013 rules. We also noted that the respondent did not raise any objection to the claimant's position. HKIAC concluded that the test under Articles 19.4 and 1.1 of the 2013 rules were satisfied and decided to proceed to administer under those rules. And since any jurisdictional question will be decided by the tribunal, we consider that HKIAC's decision to proceed will cause limited prejudice to the respondent. Now, on that note, I would like to now invite Carl to share his thoughts on how he would approach this arbitration clause if he was appointed as the arbitral tribunal. Carl, your thoughts, please. Thank you.
Yes, thank you, Joe, for this difficult question, because I find that this clause is considered problematic in expressing both a clear will of the parties to arbitrate and how they wish to do so, as well as also it's the additional challenge is not having the position of one of the parties, which I find crucial before me. But if the respondent failed to participate in the arbitration as well, I believe that I would find that this clause did not permit me to proceed as arbitrator. I have insufficient information about the will of the parties to submit themselves to an arbitral institution, as well as also the insufficient information that's the respondent that I can construct the respondent's position on the point. It would be a narrow question, and I think certainly the HKIAC's approach on a prima facie basis is correct, but my own interpretation of this clause would be that I could not proceed with sufficient certainty absent a respondent proceeding in the before with additional evidence to help me construct what the actual party's position was at the time.
That's interesting.
I will add as well
Yeah.
that I do find that this is actually a most useful lesson on construction. I was encouraged to see the number of participants who voted in response to the poll after my presentation that the reliance on an institutional standard clause is the safest course, something I completely agree with. This also suggests two other problems that arose in the contracting process. The first was that the purchaser had probably, whom I suspect in this case would probably have been the claimant in this case, had sought to impose a clause rather than genuinely discussing it, whom with the respondent, whom I suspect would have been the seller, an inequality in bargaining power that has the consequence that we see here. And the second being as well, that there was no clear engagement on this clause until the very end of the process, if there was any at all. So once again, I think it's more of a cautionary note on how clauses should be discussed and bargained for, rather than necessarily one from which we can draw broader lessons about the interpretation of the will to arbitrate on specific language that looks like this.
Thank you, Carl. I completely agree with your observations. Thanks a lot. Now we'll put out the third polling question. The third question is, which type of problematic arbitration clause do you most often see in your practice? Now you have 15 seconds to answer. Okay, here are the results. Looks like the most commonly seen problematic clause is clause referring to a non-existent arbitral institution. This is something that we certainly have seen in our cases as well. Thank you so much for your participation in the polling questions. And now we will move to the Q&A session. We have actually received quite a lot of interesting questions and for all the speakers. And the first question goes to Juliet. The question goes, can we assume that law of the seat is the law governing the arbitration agreement?
Yes, it's an interesting question, and no, we can't assume it. Different countries have different rules on this. And in fact, there's been a very recent case, literally in the last few months in England, trying to work this out. And the decision of the court was that there is a strong presumption that in the absence of express agreement between the parties, then the law of the seat will be the governing law of the arbitration agreement. But that's only a strong presumption. And that can be overturned either by an express choice of the parties. And that doesn't have to be an express choice that's actually written expressly. The court may determine that somehow the wording of that the parties have used indicates an express choice. Or they may say that it's implied, that it should be something different. So whilst it is a strong presumption, it really is not absolutely clear. And I think that's probably the same in most jurisdictions. Generally, it is felt that it's the law of the seat, but not always. So to ensure you don't have any of these issues arising, it's worth actually putting an express provision in your arbitration agreement.
Thank you, Juliet. The second question is for Carl. The question is, Carl mentioned that his personal view was to avoid ad hoc arbitration, while Juliet suggests that there were pros of ad hoc arbitration. I did some ad hoc arbitrations as well, which ran smoothly and successfully. Could Carl please further elaborate on this point?
I do acknowledge that it's a matter of experience and of preference. I'm fond of the old expression that wisdom is that's the product of wisdom are good decisions, and that wisdom comes from bad decisions. I've been involved over many years in ad hoc and institutional arbitrations, and I've consistently found that while there are exceptions in both directions, I must acknowledge, that generally ad hoc arbitrations take longer, cost more, and get less buy-in from commercial parties. And so from that point of view, my own preference, and I acknowledge that this is just a preference, is that I do prefer to work with strong, internationally recognized institutions, and that while there may be exceptional circumstances where I may agree to an ad hoc arbitration clause, I will tend to insist in negotiations that while it may not be the institution that we've started with in the discussions, there will be an institution.
Thank you, Carl.
Joe,
yeah.
Could I add a comment on that?
Sure, Juliet.
From the perspective of an arbitrator, I can confirm that most arbitrators are far more comfortable having an institutional arbitration rather than an ad hoc. It tends to run more smoothly unless, as I said earlier, the parties really are collaborative and working well. And therefore, sometimes you can't get the arbitrator you want for an ad hoc arbitration. I certainly struggled at times as counsel trying to get the arbitrator that my clients really desperately wanted, because that person wasn't willing to be an arbitrator in an ad hoc arbitration. Things can be made easier by, as I said, having an institution acting as fund holder, so you take those issues out of the way. But unless you really do have collaborative parties, I loved Carl's comment of nothing is as expensive as cheap, and that can certainly be the situation here.
Thank you, Juliet. The next question is also for you, Juliet. It is, are all arbitrations confidential?
Thank you, Joe, for asking this. This is a really common misconception that just by saying it's arbitration, that in itself makes it confidential, and that's not the case. Most institutions provide that the arbitration is to be confidential. So, for example, Article 45 of the HKIAC or Article 39 of HKIAC. However, the ICC doesn't have a confidentiality provision, and not all institutions do. And if you don't go for an institutional arbitration, and if you don't provide for a confidentiality in your ad hoc arbitration agreement, then it will depend on the law of the seat as to whether there's any statutory obligation on arbitrations to be confidential. And that's certainly not the case around the world.
Thank you, Juliet. The next question is for me. The question is, what needs to be included in an arbitration agreement in order to secure access to interim relief from the mainland Chinese courts under the Hong Kong Mainland Agreement on interim measures? This is a great question. Let me just first briefly explain what the arrangement is for the benefit of those who are not familiar. The Hong Kong Mainland Arrangement on interim measures provides a reciprocal regime for a party to eligible Hong Kong City arbitration to apply for interim relief on the mainland Chinese courts, and equally for the party to arbitration administered by the mainland arbitral institution to seek interim measures from the Hong Kong courts. Now, this arrangement is can be said is groundbreaking because it is the first time that there is a legal framework that allows the mainland Chinese courts to issue interim relief in support of an arbitration city outside of the mainland China. So if you are a company and the availability of interim measures from the mainland Chinese courts to protect your interests in the PRC is critical, then you should take note of this arrangement and consider how to take advantage of this arrangement in your dispute. To make sure that the arrangement applies to your arbitration agreement, there are two drafting points you need to remember. And one is to specify Hong Kong as the seat of the arbitration, because the arrangement only applies to arbitration proceedings sitting in Hong Kong or on the mainland. The second point is that to choose an arbitral institution that is qualified under the arrangement. Currently, there are only 6 arbitral institutions based in Hong Kong that are qualified for the purposes of the arrangement. HKIAC is one of them. So these are the two drafting points you need to take note of, to choose Hong Kong as the seat and to choose a qualified arbitral institution to take advantage of the arrangement. Okay, the next question is from Carl. The question is, what would be your recommendation in relation to the number of arbitrators, 1 or 3? Is a workable decision to use the following approach related to the number of arbitrators? The number of arbitrators shall be 1 if the amount in dispute equals or is less than 1 million euros. The number of arbitrators shall be 3 if the amount in dispute exceeds 1 million euros.
Thanks, Joe. That's a deeply interesting question, and is one that is commonly, comes up quite commonly in practical terms. The academic studies show that there is little or no difference between the outcomes, whether 1 or 3 arbitrators are impaneled. However, as Juliet referred to in her presentation, there's a deep psychological point of view that is common, I think, to all clients in feeling that the arbitral process is more representative, and perhaps an award, even an award that goes against the interests of that client, is more easily accepted if, quote, an arbitrator representing that party is. So I think the great problem with defining it in pure financial terms is, what is the amount in dispute? It's often the case that at the moment an arbitration commences and a tribunal is appointed, that the amount in dispute is unclear, either because the amount of relief has not been quantified, or the amount of relief sought may change over the course of the arbitration, and also because counterclaims may not yet have been taken into account. There's a game that's played, especially when ad valorem fees are the applicable standard for the tribunal, of underestimating the amounts at stake in the early stages of the dispute, only for that amount to grow over time. And I would suggest that this is a decision that should be made upfront. I think you can take courage from the fact that the academic studies do suggest that there's really no difference in the outcomes between 1 and 3 arbitrators, or you can decide psychology is the more important point and that you want your client bought into the tribunal, given the opportunity to appoint one of its members. Using the value in dispute approach should work only in the simplest of circumstances. Otherwise, it creates potential issues that may later arise in terms of what if the value in dispute is below $1 million as the tribunal is impaneled, but rises to 10 million during the course of the dispute. Anything that threatens the enforceability of the award should, from my point of view, be avoided unless there really is no alternative.
Great, Carl, thank you. Juliet, I wonder whether you have any thoughts on that question.
I did, but Carl has answered pretty much all of them. I thought I completely agree with everything Carl had said. The only thing I would add is that there is this psychological need to feel that you have to have, quotes, your arbitrator on the tribunal. And I can understand that from having been counsel. I'd like to assure everybody that's listening that on the whole, having your arbitrator on the tribunal does have some benefits, because they will ensure that everything that you've been trying to explain to the tribunal is heard and is properly discussed. However, quotes, your arbitrator, it's very rare to see one who is going to automatically fine for the party that appointed them. It does happen, sadly, but it's very rare. And therefore, you are paying a lot more money and maybe taking more time in your arbitration to have that psychological feel that you've been heard. That can be very important, but don't overestimate the importance of that or the value of it.
Thank you, Juliet. We still have a lot of excellent questions, but unfortunately, in the interest of time, we won't be able to answer all of them. Finally, I just wanted to put out this slide which shows our upcoming webinars. I wanted to highlight our next webinar, which is Virtual Hearings, How Best to Proceed, HKIAC Insights. It will take place on 15th May. And for further details of this and other webinars, you can find that on HKIAC's website. This brings to the end of our webinar today. It remains for me to thank Juliet and Carl for the excellent contributions to the discussion today, and also for all the audience members to take the time to participate in the webinar today. Thank you very much.
Thank you, Joe.
Thanks to all of you as well.